Um,
That's okay.
So this is Paul Clark. And as I said, it's 1:20 a.m., 1:18 a.m., where he is in the UK. He is a barrister in the Garden Court Chambers in the UK and has a very extensive practice focused a lot on, well, international human rights law, domestic human rights in the UK, does a lot of work on prisoners' rights, as well as right now he's involved in, actually at this moment, in an inquest that he does. He's involved in a lot of inquest. What do you call that when you're involved in inquests? You're litigating for inquests. You're working through the inquest. What's the term? We don't use it.
Well, coroners will repeatedly tell you it's not litigation, blah, 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 but I guess it's just an inquiry. I don't know.
Okay. Okay. Yeah. So he's also done work in prison law and immigration detention, and has been involved on bringing actions against police as well. And a lot of that's related to the Inquisition work. And he's been involved in 3 major international law trials. So no, more than that. And so you were involved in the Taylor trial, which we just saw some on in the film, as well as 2 cases before the International Criminal Court, and 1 in the ICTY, and always on the defense team, right?
Yeah, at the ICTY, I was working in chambers, so I was working for the judges, but my heart is definitely in defense.
Okay, but that's a good place to start, because this was your first job, was working on the defense team for Issa Sesay with Wayne Jordache and Sarita, who we saw in the film. And why don't you tell us how you got involved in that case when you were 10 years old?
Certainly. Before that, Karen, I'm struggling with the sound a little bit. I'm only catching
okay.
fragments of what you're saying, unfortunately.
Yeah. Sarah's. Okay. You can't even see. That is me. Yeah. Okay. We'll try from there. So can you?
Oh, that's better.
How you first got involved in the case?
All right. Well, it was my first job, and the trajectory was immediately following an LLM degree at McGill in Montreal, and like many students at that university at that time, and perhaps elsewhere, I was fully signed up to the idea that law was something which could achieve good things in the world, and it seemed like international criminal law was, first of all, interesting and new, and also something that offered a kind of political project which hadn't been offered by really any other type of legal endeavor. Certainly that was the way it looked to me. So I'd spent a master's degree which was orientated around an interest in international criminal law in various different ways. I'd written a thesis on victim participation, victims' rights, and I was looking for a job. And so I did a short course in London and happened to get involved in a conversation which somehow a few days later led to an offer to join a defense team at the Special Court Sierra Leone, working with a couple of lawyers from the types of chambers that I really wanted to be in, people I admired, but working for the defense. And given my trajectory and given everything that I'd thought about international criminal law up to that point, I probably thought somewhere in my mind that the defense was probably the last thing that I wanted to do in those types of trials. The idea that victims' rights were being pursued was something that I wanted to uphold, not to prevent. So about a week later, a lot of injections and immunizations very quickly. I found myself in Freetown, and the day after I arrived, I was there in court trying to figure out what was what. So shall I go on from that, Karen, or do you want to?
Yeah, so I just want to highlight, so I think it'll be obvious to some people in the room, like in the seminar, but maybe not others. So you when you decided to do international criminal law because you were interested in victims' rights, you assumed that would mean you would be on the prosecution team or maybe working in the chambers as you were in the ICTY, but you ended up in the defense. And how did that change your thinking about human rights, about international criminal law, and specifically in relationship? I mean, obviously this case had a big impact on you.
Well, not only because of obviously the physical environment of the town. The first time I'd been to West Africa, and I'd arrived in the middle of the night and didn't quite know where it was that I was even sleeping or living, and just turned up and was given a room in a place. A few hours later, I found myself in this courtroom inside of a building that looks an awful lot like an extraterrestrial spaceship that's landed in the middle of a completely alien landscape. So the two things just don't make any sense together. The environment and the building. I don't know if you've seen what it looks like. It probably does come up in the film a few times, actually, now that I think about it. And I have to say that my first day in court was one of the most personally shocking experiences I've ever had in my life. It was within the first 15 minutes that I started to feel like there was some kind of something other than a benign, neutral rule of law flavor to what was going on. And that feeling essentially grew and grew. I remember going home, not just the first night, but the first, second, third, perhaps first 2 weeks of my first days in court, unable really to express the way I was feeling about it, because it was shocking. There were from the point of view of somebody seeking to practice law, it felt like the process wasn't good enough. It felt like there was a lack of quality. It felt like there was something else going on that I hadn't really got my head around. And that sort of feeling from being a sense about professional competence and about good process started to grow outwards into ideas about how there might be economics or politics or culture driving some of these things, and that there are an awful lot of different angles on that. There's been a number of good pieces of writing done about the interpretation of evidence and the cultural effects of that. And I think that was an element of it, the kind of disconnect that I felt that there was between some of the witnesses and the questions that were being asked, and whether or not the answers were intended to be as they were phrased. But broadly, it's very hard to pin down exactly where this unease came from, or exactly what it was that was driving it, because it's so unbelievably multifaceted. And as time went past, it became totally clear to me that this was not a fair trial, could not have been a fair trial, and nobody who had real control over the way the process was going, if anybody did, if it is as simple as that, wanted it to be a fair trial. And I found that, in my naive way, incredibly personally shocking and disturbing.
Okay, so one of the things that's difficult, obviously, about Rebecca not being here with us is that the film, so I just feel like I'm going to step in for her for a second, and then maybe we can open up for questions. But because the film is known as being, there are a lot of documentaries about international criminal courts, and this one is known as being maybe the most defense-oriented, or maybe the most even-handed, is how a lot of people refer to it. And in fact, Stephen Rapp, who is the second prosecutor, was, I'm pretty sure he's the one who Rebecca says has gone around and promoted the film and said he really likes the film because it shows how this person got a fair trial, and then sort of takes you through the whole process. And but we heard your side of things in the film a lot because of Wayne and Sarita in there, and we also put the other side. And just another thing I'll mention for the folks who are watching it is that there was a lot. I guess originally there was a lot more David Crane in the film, and some prosecutors who helped edit the film said, really, you don't need him in there so much. He doesn't make us look so good. But then apparently he also was pretty happy with the film. So it's not, you know, he's I think you see that both sides have a lot of conviction about what they're doing in terms of it being what they think they're seeking justice. So I think with that, maybe we should just open it up and get folks. And I have a question I want to come back to you at the end to get you to talk a little bit about your other work and how it fits with this. But I'm sure that there are questions. Yes.
One of the things that we heard Wayne say toward the end of the film was just what sounded really like his lack of faith in systems like these international courts that come in. He referred to them as arrogant, and just he really, you know, was very disappointed into that as a system of justice. And I wondered if you have any thoughts that you might share on, you know, what might a different model look like. Because one of the questions that we're kind of thinking about at the Rappaport Center as we explore questions of prison abolition and others is, you know, who wins and who loses in these systems that emphasize, you know, punishment or punitive consequences are dominant. So I wondered if you had any thoughts on, you know, what a different model might look like, or just a different system if these kind of international courts aren't doing the job that they set out to.
Yeah, well, if we're doing a sort of a normative redesign of institutions thing, I think the starting point should be the word modesty. Because modesty of aims, modesty of ideology, and perhaps even modesty of budget, of indictment, of philosophy. The point that I'm making is that I think that at the core of this at the core, I don't want to make as big a claim as that, but an important idea in these trials is the idea of the monster. You know, I think when people hear people like me moaning on about unfair process in the international trials, and people like Wayne saying what he says about joint criminal enterprise and indictments, etc., and I'm more than happy to bore you to tears about that. Ultimately, what drives it is a number of linked ideas. You know, one is in terms of the reaction that people will tend to have, it's a sort of slightly removed reaction where I think people think, well, why should we care that much about this? You know, these are prosecutions of the worst possible crimes, and the people who are being pursued have been chosen as holding a great deal of power. So there's a sort of a distancing, I think, from concern over fairness that's felt by society at large, whoever that is, when hearing people making these fairness critiques. Another aspect of it is the actual person at the core of it. And you've heard Wayne talk about Issa, and I've had it's a real privilege to have spent a huge amount of time in the detention center in Freetown with him, just while I was getting my head around the case and then taking instructions and everything else. And he was only the starting point for a realization for me, which is that at least in any of the international trials that I've had any involvement in, surprisingly perhaps from the outside, there's been a solid defense argument to run in all of them. It's not bad faith. So this idea that whoever it is being prosecuted must be either really bad or really, really bad, really. So why do we care that much about fairness? I think the moment you start to poke holes in that, you start to think perhaps there isn't such a thing as this radical evil monster that the paradigm of the international trial. And if you come to that realization, then you stop being worried so much, perhaps, about the idea that the sheer size and scale of a given trial has to replicate the enormity of the evil that it's supposed to chase after. And once that happens, you think, well, why do our indictments need to be so ridiculously enormous? If the indictments aren't so massive in factual scope and so broad in the seriousness of the crimes they allege, then it's possible for those indictments to be specific, more specific enough for a defense team to actually be able to prepare a defense, which would be nice. And by way of illustration of that, when we got to the end of this I think 5-year process, while we were writing the closing brief, we counted literally hundreds of new, separate, distinct allegations of crimes that Issa was accused of and also ultimately held responsible for, which we could have never known about being part of the prosecution case by the way the indictment was framed. And there's this idea that appears in the jurisprudence very often that there's some kind of compromise made, whether it's around rules of evidence, usually quite banal procedural things, but those things are compromised in order to be able to pursue the scale and gravity of the crimes. That scale and gravity is a myth. The events, the infliction of horror and pain, that's a reality. But the myth is that it's politically coherent to make a prosecutorial link that satisfies what you would see as comparators within your own intuitions about fairness within domestic law. It's just simply not possible to make that coherent political link between that enormity of horror and a particular individual. And that's because those things don't happen because of radical evil. They happen because of the collapse of what I would call normal politics, which makes that kind of horror, that kind of atrocity, far more human and far less evil in nature, and that's a really uncomfortable idea.
I have a follow-up, but I think we should open it up. Yeah, I think you're gonna have to speak up.
So the prosecution seems to be really well funded. And I guess I was wondering, since you've been working with defenses, where does the defense money come from? How are the defenses funded?
It comes from a very, very small pot given out by the registry. So you're absolutely right to point to a massive disparity in resources, and it's clear whenever you can, in the special court and any other international court. We had a small porter cabin between us, a porter cabin. There were 3 desks in it, and there were barely enough room for us all to fit in it, along with all the papers at the same time. The prosecution, on the other hand, had the buildings that you've seen, had almost, it felt to us like infinite resources, investigators, everything else. You could make an argument that there are certain logistical differences between the prosecutorial task and the defense task, and you could get into arguments about budgets for a long time. But I think rather than doing some kind of accountancy exercise for you right now, I think where the issue around funding became really, really stark was something that came to light while I was there towards the end of the trial, which came about from the question of support provided to witnesses. Now, there's quite a complicated set of arrangements in I think, all of the international tribunals, whereby during the investigative phase, before it's identified that a particular person will be a witness, rather that they're just part of they're a potential witness, there's funding and money for the prosecution to be able to support the process of obtaining their evidence. And that makes sense. Often that involves a great deal of travel. It may involve some danger. It may involve a number of things. And it's right that the process of investigation should be properly funded. But some time has to come when it becomes improper that any further money is provided by the prosecution to somebody who is confirmed as a witness, when the idea that whatever support is provided to a particular person is no longer about facilitating them coming to a particular place to answer a prosecution investigator's questions, but instead is about something else. And that something else in the context of international tribunals is a particularly difficult task, because understandably, one of the features of these kinds of trials is that the logistics and the risks, that there'll be a greater expense for logistics for witnesses to actually come and provide their testimony. But also there'll be things like potential need for victim protection. There may be situations in which there may be a need for certain types of support. The whole idea of witness re-traumatization is something which has been written about in great detail, and then dealing properly with the potential psychological effects of giving testimony can be also something which requires resources. Now, that giving of resources is something which is a necessity, But if that is comes structurally from the prosecution, then understandably, at least you'd have a situation where there looked like an unfairness, even if that witness's testimony wasn't affected at all. In practical reality, I know from personal experience and anecdote that there were people in bars in Sierra Leone talking very loudly about how they had a new house because they'd been a witness in the special court, and everyone else should do that too. And in the context of not only the fact that's a prosecution witness, but also the inertia of an institution which seeks to end impunity. You know, you can't do ending impunity if you don't do punity. You know, so there's an idea that what's valuable should be in that direction. There's not just an unspoken, but certainly an unspoken, a huge amount of an incentive is felt by certain witnesses to serve the prosecution's needs. And that may all sound like speculation from me, but we got a sniff of this during the trial process, and we started to ask for information about the kinds of payments that were being made and from whom. And certainly by the time I joined the team, it was well into the trial, and there was almost, well, there's no justification whatsoever for there to be continued payments and support coming specifically from the prosecution rather than from the Victims and Witnesses Unit, which is a separate thing, part of the registry, not part of the prosecution. And what we uncovered were literally scores of entirely either unexplained or ill-explained payments once we got that piece of disclosure. And that was once we figured that out, we then made the kinds of applications that you'd probably expect to have some of their evidence excluded, and to have the certain aspects of the case thrown out. Now, the motion that we filed for that was basically a list which was, I think, somewhere in the region of 40 to 60 pages long of what we said were either unexplained or plainly illegitimate payments. And interestingly, the response to it, well, not interestingly, the motion was thrown out. The decision that we received on that was no more than a few sentences long, effectively an assertion that there needed to be support and there needed to be payments of certain type, no attempt to investigate it at all. And it had absolutely no bearing on the trial process whatsoever. And to our minds, I think, and perhaps certainly to the one reporter in the world who picked up on it, it was an absolute scandal. It's not to say that support isn't warranted and shouldn't be provided, but the resources of the prosecution and the enormity of those compared to the defense, it certainly looked like they were being used in a way which was knowingly allowing witnesses to benefit in a way which is plainly would not be acceptable in any kind of domestic process.
Paul, I'm just going to start. Yeah. No, I mean, that's actually really useful to go through and remind us that there were motions behind, because in the film, and Paul, it's been a while since you've seen the film, just agreed to do this today, and that was a long time ago, even that the film came out, but we saw, two witnesses. One, it was really weird because the witness just said, it's not because of money, it's because of my loyalty to God that I'm testifying this way. And you're like, what happened before that? Why did they even say that? And the second one, they get into a fair amount of detail, and there's a fight between the witness and the defense investigator, or the defense who's doing the questioning of the witness. But it's like, I hadn't thought about they weren't objecting to it being there. They were just using it for cross-examination. And so it sounds like an objection to there that we wouldn't have seen in the film, obviously. We just have a few more minutes, so I wonder, I kind of would like to, even though you won't have time to answer them, can we just collect some other questions people had? Yes.
I had just one question. We were talking about the ineptitude of some of the players, and I'm wondering what your thoughts are. One, how many judges are there in the court, and what was their proficiency or fairness or abilities, from your opinion?
I don't think it'd be right for me to comment on that. But they were from a range of backgrounds. There were 3 on trial and 5 on appeal. There was a Ugandan, Canadian, and a Sierra Leonean on the trial.
Thank
Are there any other burning questions?
I should say, just to follow up on that, just briefly, the idea that it's simple ineptitude, the idea of ineptitude fell away from my analysis of this very quickly. It wasn't just people not very good at their job. It was the fact that this institution exists in a particular type of political environment in which it makes claims which are far bigger than it is, and actually has a political constituency which is both of a particular type, which is different from what you might think it is, and also much smaller than you think it is. So the fact that only one newspaper picked up on the payment story is one example of a lack of really viable political constituency, a lack of real friction of the type that would undoubtedly arise if a similar kind of allegation of corruption arose in the domestic context.
Yeah, and I think that was also, so just to go back to maybe your answer to the first question about what alternatives there were, and your response was modesty. And then you actually went into a discussion about, well, maybe bringing, it sounded like more specific charges, kind of making it more like an ordinary criminal court. And then people would be able to defend on those, the defense counsel would know what's in the indictment, be able to respond, et cetera. You didn't go outside of that to sort of what a world might be, other than a more modest criminal court. But I think that was a line that we heard a lot in the film too, just about, and mainly from DoorDash, like this court can't possibly do what it's expected to do. And that's something that we hear pretty commonly about international criminal law. Okay, so in 2 minutes, do you see, and this is maybe a follow-up on the first question too, so sometimes you're engaged, you've been in the defense, on the defense side or in the chambers with regard to international criminal law. You have done a fair amount of defense work domestically, but actually a lot of your work domestically is about sort of trying to get to truth, understanding circumstances about what happened to individuals through the inquest, for example, that might end up leading to prosecutions. And then I know you're doing some work trying to hold corporations accountable criminally. So I wonder if you could just say a word or two about what emancipatory potential you see for criminal law, and in what circumstances.
Well, I mean, I'm in terms of the idea of there being a claim about the value of any given legal project per se, I'm completely ambivalent. So I don't think that criminal law is, I certainly don't think it's an inherently good thing. I think it's very frequently a bad thing. But there are times when it can be used in a strategic way, which is useful. So, for example, very often one of the types of things that some of the bereaved families that I represent in prison deaths, or when somebody has usually a black man, has been restrained by the police and dies of positional asphyxia. One of the things that they want to pursue is criminal justice, and it's complicated, I think, to understand exactly what the emancipatory value is of that. I think it's tempting to do a sort of large critique that criminal law is bad top to bottom, to say that it reifies certain types of structures which themselves are part of the problem, economically, politically, whatever. But you can't change the fact that when you have a client in front of you, they're not going to be able to live in a world within the next 5, 10, 15, 20 years in which there's no criminal law, there's no institution of particular type. So that client wants something to be done. And that, I think that is helpful, at least in terms of understanding what political potential, what emancipatory potential you might be able to achieve with a particular piece of work. Because at any particular moment, there's always an ideological claim to be made. You know, you could say, well, criminal law is going to do deterrence, is going to do repression of crimes, will prevent these things from happening again. Or you could say it's completely pointless. Actually, within the nuts and bolts of a particular case, neither of those things are true. And the focus just has to be on the client. Now, in terms of choosing when to do that, certainly, I think there's an obvious strategic choice to be made as between when the inertia is indicative of criminal prosecutions happening frequently and when it's not. And two situations that I frequently am involved in and seeking to make prosecution happen is where it's against agents of the state, usually, but not only the police, or also against corporate activity. So it might be said that in a fairly simplistic way that there's an emancipatory strategic value to pursuing that, which would be hard to. It would be hard to deny that, I think, in the face of a particular client at a particular time, even if some of the structural critiques are entirely sensible, and even if it's possible to say that the project that you're pursuing is institutionally bad and corrupt from top to bottom.
All right. I was with the window up when I was introducing you. I didn't say a couple of things, which is that Paul was one of the finalists for Legal Aid Lawyer of the Year in the UK in 2017. And I think you can see why. And that you're amazing how well you're talking at this hour. The wallpaper is lovely, and we hope to get you here in person soon. So thank you very, very much.
Thank you very much indeed. Thank you. Very kind.
Good night. I hear you're going back to work.
I am, yeah. I've got a few hours yet.
All right.
Nice to see you.
Take care. Thanks a lot, Paul.
No worries. Good night.
Thanks, Paul.
Thank you all.
Bye-bye.